Hello, this is Matt on the Moon Lambeau channel. Ripple wins in court again. Yes, indeed. SEC. Sorry, not sorry, my friends, but I think it may be the case that you have overestimated the strength of a number of your positions. And here's a headline from Crypto News Flash. Ripple wins again. SEC's request for disclosure of Brad Garlinghouse's and Larson's personal financial records denied. And so I've got opinions from a few different attorneys here on this latest Moon Lambeau hot jam. It's going to be a good time. But I do want to be clear at the outset here. I don't have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm nothing more than an enthusiast who enjoys making YouTube videos for fun about Ripple and XRP and cryptocurrency in general, but that is all that this is. And so here you go. You basically got the SEC getting bitch smacked by Ripple again, and oh, it feels so good. The piece begins as follows. Ripple has scored its next victory in its legal battle with the U.S. Securities and Exchange Commission. Judge Netburn yesterday denied the SEC's request to produce the personal financial records of Brad Garlinghouse and Chris Larson. And you know what? I'm kind of disappointed in a way. I wanted it all to come out because I just like you, I'm sure you got to be the same as me, right? We all wanted to know what types of groceries Brad Garlinghouse and Chris Larson have been purchasing, because that's the type of information, like if you just let everything out there, which is what the SEC is saying they wanted, you just have full disclosure of everything that they're purchasing. We would know how much avocado toast Brad Garlinghouse has been purchasing on the rec, and I'm willing to bet it's a lot, because that's what you do out there in San Francisco and in Silicon Valley. That's what you do. You sustain yourself. The sustenance for these people out there, it's almost 100% avocado toast. That is my understanding. You out there listening in California, you let me know if that's true or not, but I believe that to be the case as I record this here and now. Now, as Crypto News Flash reported, the regulator claims the documents could be relevant to the individual lawsuits against Ripple's chiefs to prove the sanity of the individual defendants and their efforts to increase the value of XRP. And that's a quote, by the way. Now, Magistrate Judge Sarah Netburn, however, sees it differently. In her reasons, Netburn writes that, quote, the SEC's requests for the individual defendants' personal financial records, apart from those records of XRP transactions that are already promised, are not relevant or proportional to the needs of the case, end quote. So it's just, if you're a person of reasonable intelligence, which is at least everybody listening here, like I'd like to think that people in the XRP community are well informed, probably of above average intelligence. But even if you just have average intelligence, and even if you're just kind of okay at logic, you can figure out inside of a minute or two that what the SEC was asking for, as I've highlighted on this channel in previous videos, it's a tremendous overreach, and it's not necessary for them to prove what it is that they wanted to prove. It's not necessary in the least, but the SEC, I feel like they're being bullies. Like they're overreaching, and they must clearly think that they can get away with this stuff, but they're not. They're losing. They're losing so far. And so, as Netburn explains, the party seeking disclosure has the initial burden of proving that the disclosure is relevant. However, the SEC was unable to provide the evidence of relevance. Notably, the SEC had already received all trading records related to the sale and transfers of XRP by Garlinghouse and Larson, as well as all financial records related to the compensation they received from Ripple. You know, and in one of the court hearings, and I'm pulling from memory here, but I do remember it being brought up when they asked, okay, what's the relevance of all of this before this decision was made? The judge was asking, and ultimately, the question was brought up, okay, why is this all necessary if there's no sort of fraud charge? What is the purpose functionally of this? Because think about this, if Brad Garlinghouse and Chris Larson sold their XRP and there's no fraud charges, why are you trying to get into that level of detail? It just doesn't make any damn sense. And the piece continues, the personal bank records, according to Netburn, do not have the ability to prove what the SEC alleges, individual violations of U.S. securities regulations. Moreover, the SEC also failed to produce evidence of covered-up transactions by Ripple bosses, and Judge Netburn stated the following. The SEC has not presented any evidence the individual defendants have hidden transactions or that the documents produced support an inference of hidden transactions. The SEC's belief that the individual defendants' banking records might show evidence of a speculative transaction that could have occurred, and that the individual defendants are not providing in their XRP transaction records, is not a foundation on which to order expansive discovery into personal financial accounts. Round of applause right there. You gotta love it. Oh, yeah. The SEC's just getting their ass handed to them. I don't mind seeing that one bit because I'm disgusted by their behavior and the degree to which they're unethical, hypocritical, and illogical. Because you know what they're running on here? It's basically the Chewbacca defense. It's that type of tactic. It is the Chewbacca defense. What Wookiees living on Endor? I don't make no damn sense. Ain't nobody got time for that jibber jabber. Piece continues. As a result of the final of the decision, the SEC must withdraw its request for production of the individual defendants' personal financial records and its third-party subpoenas. However, if the SEC still finds evidence that Garlinghouse and Larson are concealing XRP transactions, the request may be renewed. Hey, perfectly fine. Sounds reasonable. And here's another quote. If, as discovery progresses, the SEC uncovers evidence that the individual defendants have not been forthcoming with records of their XRP transactions, it may provide such evidence to the court and renew its application. There you go. Yeah. I mean, wouldn't that be a sign to look further? If they were actually, and it seemed clear that Brad and Chris were actually lying. I can't imagine them do this, but would it be reasonable to dig further? Like, I have no problem with any of this whatsoever. It seems all perfectly reasonable to me. Now, let's get into what attorney John Deaton had to say. He's a member of the XRP community. He's not I shouldn't say that, actually. Initially, he wasn't involved in the case with the SEC versus Ripple, but he is seeking to intervene right now, and so we'll see if that happens. He's I don't think he's filed yet, but he will be filing a motion to intervene. He's gotten permission from Judge Annalisa Torres to do so. And even just that seems like a little bit of victory. Let's celebrate the small victories along the way. That's something. So we don't know for sure if he's going to be allowed to intervene, but he's allowed to file to attempt to get in there. And then it would be on behalf of over 10,000 XRP holders that have contacted him. And so the point of that being, it's because look, the SEC is representing their position and Ripple's representing their own interests. And who's looking out for the XRP holder? Well, nobody but John Deaton, effectively. And so it would be nice to get our voices as XRP holders heard there. So we'll see if that ultimately happens there. But anyway, so John Deaton, in that sense, an outsider, but very well known in the XRP community, and he's garnered quite a following in short order and well-deserved. In fact, I encourage you, if you've not yet followed him, to hop on Twitter. He is at John, his first name, John. Middle initial E, and then Deaton is the last name, Deaton, and then the number 1. And here's what he wrote in response to all this. I've appeared before more than 100 judges in 15 different jurisdictions during my legal career. Who you draw as the judge on any particular case makes a huge difference. Even if we lose on intervention, XRP holders are lucky that Judge Knepper and Judge Torres were assigned this case. And then John Deaton also wrote this. It will be a 3-0 when the judge dismisses the case against Brad Garlinghouse and Chris Larson. Let me pause right there before reading the rest. So when he says 3-0, he's talking about victories along the way. So the first one would have been that that Ripple wants the SEC records, any sort of internal memos, this and that, having to do with the thought process behind determining that Bitcoin and Ethereum are not securities. Ripple wants anything having to do with that, any internal documents with the SEC to be made discoverable so that you can actually use it as evidence in court. And Ripple did get a victory there. The judge agreed, yes, absolutely, this is relevant to the case. And the SEC said, no, it's not relevant to the case. Of course it is, but this is just them being disingenuous. So the judges sided with Ripple, and that will be used as evidence. And so we're hoping there's going to be some sort of smoking gun. Don't know if there's going to be, but I'll tell you what, if there's anything in there indicating that XRP effectively, of what it is today, would be in line with what their thought process is for why Bitcoin and Ether are not securities, That would really be something, and there could be, we don't know, but we're going to sit back and be optimistic here. Either way, we need to have an understanding of this, and it's completely irrelevant, so that's happened. So that was the first one. The second one is what we were just talking about here in this video, just the personal finances. Just judge says, no, that cannot be evidence. That's the second one. And so what John Deaton here is saying the third one will be John Deaton said when, but if ultimately Brad Garlinghouse and Chris Larson end up having their charges dropped, which is different than, like, the charges with Ripple, those are going to persist because they're not even attempting to have them dismissed. But Brad and Chris both are motioning to dismiss the charges against them. And so that would be the third one. So John Deaton wrote the following. It will be 3-0 when the judge dismisses the case against Brad Garlinghouse and Chris Larson. The best proof, they allege, is from legal advice that XRP could be considered a security under certain conditions. Hey Satoshi, Bitcoin can be a security if you use it like a security. Exactly. Which is why that's really not a good argument. So that's what the SEC is arguing effectively. The reason that you shouldn't drop this is because, look, by Brad Garlinghouse and Chris Larson, by their own lawyers, and Ripple's lawyers were warned that the SEC could view this as a security. But just because there's a risk of the SEC doing something that's illogical, that doesn't mean that you shouldn't proceed with what you're doing. Any number of things could happen legally. It's about understanding that there could be risk that you vehemently disagree with. Should it come to pass, come to be a reality. But that's not an argument. So that's what the SEC is saying. It just seems like a piss poor argument to me, to be perfectly honest with you. It really does. And so that's the best proof that they have, is that it could be a security, and that the lawyers said, yeah, it could have been. Yeah, okay, well, you know what? I could be walking down the street and I could get hit by a bus tomorrow. That would suck. Moon them will go splat. But it doesn't mean that's going to happen. And it's not a reason to not go out into the world. It's just stupid. It's just the stupidest train of thought here. Now we have XRP community member and attorney Jeremy Hogan, who shared the following on this. I recently suggested that the court would not grant Ripple's motion for discovery if it intended to dismiss the fair notice defense. And so let me pause right there. The fair notice defense, what we're talking about there, is Ripple, and if this is a great point that Ripple's brought up, it's totally legit, that they've been operating for 8 years, and market participants like exchanges and hedge funds, in addition to Ripple operating, exchanges and hedge funds had sit-down conversations with the SEC articulating why they don't believe that XRP is a security, and SEC allowed them to continue to proceed selling XRP without any sort of warning that, hey, this thing is a security or might be a security. There was nothing like that. And so Ripple just kept chugging along, and now almost a decade later, the SEC comes after them, and they didn't get fair notice that what they were doing was wrong for almost a decade. And that's actually an actual strong argument. And so what they're talking about here is what Jeremy said again. I recently suggested that the court would not grant Ripple's motion for discovery if it intended to dismiss the fair notice defense. Right. And so that's what he was referencing right there. And as far as what was discoverable, it was this information about Bitcoin and Ether, and what the SEC might have said or thought internally what it was over the course of the last decade. That information would not be relevant if the SEC, if the judge was determined to throw out the fair notice defense of Ripple. You don't need the evidence that would be relevant to that if you're throwing it out. And so that's why Jeremy Hogan stated that. And then moving along, he wrote, inversely, I think that Brad/Chris can take this as a good sign as to their motions to dismiss the lawsuits against them. Yeah, so just this idea that the judge already thinks, no, you're not getting the personal finances. Well, if that didn't happen, then it would be less likely that the motions to dismiss the charges against Brad and Chris would be less likely that they'd actually be dismissed. But since this happened, seemingly more likely. Jeremy Hogan also then wrote, the judge again makes remarks that the technical/operational aspects of XRP are important to the case. Ripple wants it to be about that. The SEC wants to stay clear of that. They want it to be only about marketing and money, but this judge is saying otherwise. Don't mind hearing that one little baby-boo bit. So there you go, another victory along the way. I'm just hoping that at some point, especially now that the SEC's internal documents pertaining to Bitcoin and Ethereum are going to be admissible in court, I'm just hoping that that's going to result in a settlement that otherwise perhaps wouldn't have occurred. And it's possible. You know, the lawyers that I cover on this channel that are within the XRP community have been saying, hey, that actually could be a thing. And I think that Jeremy Hogan was one of them that said that as well. I'm pretty sure he was one of them anyway, but I'd previously highlighted that. So I'll wrap up there. I am not a financial advisor. Do not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.